Before we get started, we'd like to thank Nationwide for sponsoring this episode of Let's Get Surety. When you partner with Nationwide Surety, you know you're working with a strong and stable carrier that has a wealth of experience. Nationwide Surety Operations specializes in both commercial and contract surety bonds to support local, regional, national, and international customers with operations in the United States. For more information on Nationwide Surety Solutions, visit nationwide.com/surety.
You're listening to Let's Get Surety. Let me hear your bonding talk with Kat Shamapande.
Hey everyone, it's Kat Shamapande. Thanks so much for joining us for this episode of Let's Get Surety. Today we're going to be talking about tribal sovereign immunity and really what you need to know as a surety bond professional when you're working with Native American tribal government or business entities. And today I've got with me my co-host Mark McCallum, CEO of NASBP. Thanks for being on with me, Mark.
Hi, Kat. I'm really interested in hearing more about this subject.
Me too. And to do that, we have an expert with us, Michelle Randall, and she's Vice President of Surety Risk Solutions with Zurich North America.
Hi, Kat.
Thanks for being on with us, Michelle.
You bet. Great to be here.
It's great to have you on. Well, before we dive into this topic, can you tell me a little bit about yourself and what you do with Zurich?
Sure, that'd be great. So as Kat said, my name is Michelle Randall. I'm an attorney. Right now I live in Sioux Falls, South Dakota. Everyone says, what? When they live in South Dakota. Yes, that's where I am. I've been with Zurich Surety for about 6 years. And we have a team of attorneys that is actually on the underwriting side. So we're not in the claims department, which is a little bit different, I think, than some sureties. We support the underwriting team. So, some of the things that we're doing for them is looking at indemnity agreements. We're helping them negotiate those indemnity agreements with our customers. Probably more importantly, though, is, we are looking at the contracts that our customers are looking to enter into. So we're just, we're another set of eyes to look at terms and conditions, look for risks, things we can point out both, for the surety from our perspective, but also for the customers themselves so that we can say, hey, this is a risk that maybe you didn't think about. And one of those that comes up quite a bit, even more so lately, is tribal contracts where we have tribal owners. So, because that's just, it's whole different set of issues than there are with with any other type of owner.
Yeah, that's interesting because my first question was, where does surety become involved with the tribe?
Sure. I mean, where it becomes two places. So, and first, maybe let me just back up and say,
Sure.
When we talk about a tribe, we're talking about a federally recognized American Indian tribe. And I've had a couple of people ask me, hey, you're using the word Indian. I didn't think that was, appropriate. And there are certain times when, as a term of art, Indian becomes a little more, how should I say, accepted than, of course, the term Native American. So when we're referring to people in general, Native American is more appropriate. But, the body of law is considered Indian law. When we talk about lands that are owned by tribes, Indian land is appropriate as well. So I just want to get that out of the way, too.
That's an interesting clarification. Yeah.
Yeah. I've had a couple questions after I've given this presentation, at Zurich, and happy to clear that up, obviously. But so it's a term when we say that, federally recognized tribe or a village or any other type of related tribal entity. Alaskan Native corporations aren't considered tribes for this conversation. They don't share the same sovereign immunity that other American Indian tribes do. I also talk about tribal entities, and that's a general term for entities that might be affiliated with a tribe, for purposes of contracts or transactions. So, this might be an entity that's incorporated or registered under the business organization laws of a tribe. What I don't mean is a Native American owned tribe. That's a different thing. That's, an individual for like small business and 8A purposes might own a business, and they can have separate certain protections and certain opportunities. But this is an actual federally recognized tribe and its entities that it's set up. So there. background for some of the
Yeah.
terms.
Hey, Michelle. So
you,
can anybody
yeah.
find out maybe there's a federal website or whatever, a listing of the federally recognized tribes, or how do you go about that?
I don't have a website off the top of my head, but that is certainly information that would be widely
Okay.
available. One thing is if we're dealing with a tribe, one of the first things I do is just, do a web search and find their website, find out information about them. And as
Right.
I'll talk about it in a little bit. One of the important things is finding out about their how they're set up, how their judicial system works, how their tribal governance works. So, you'll find that information. I have yet to come across a tribe that doesn't have a website that at least directs me to maybe their constitution that talks about how they're set up and how they're run. And that information will be right there.
Right.
So where we run into that is two different places. First of all, and probably the most common, I think, for me anyway, is where a tribe or tribal entity is the owner on a project. So we have one of our customers coming to us and saying, hey, we're looking to enter into this contract with a tribe. What do you think? Will you give us a bond? So there's that place. And then the other place is where a tribe or a tribal entity is actually going to be a principal on a bond.
Mm.
And, there's lots of Native American tribal owned companies out there. They might be able to take advantage of some of the SBA programs that I mentioned. And once again, different from companies owned by Native American individuals. So that's where it's coming up. And, I'll talk about both of them if that's okay with you.
Yeah.
I can address both,
Yeah.
It's different in the way you look at it. And in my opinion, how much, care and detail you need to take when you're looking at waivers of sovereign immunity.
So sovereign immunity seems like a big term. It sounds very legalistic. Could you tell us what that means?
It is. So, from a very global sense, sovereignty itself refers to the government to government relationship between the United States and other countries. It also it also includes state to state. So any public entity is sovereign and has its own, sovereignty and everything that goes with it. Native tribes also. Okay, so when you think of sovereignty, you think about their inherent right of self-governance. Okay, and that's something that has been recognized by the Supreme Court in the United States. And actually, even recently, I mean, it's continued. Nothing has even come close to reversing the concept of tribal entities within the United States are considered sovereign, and the United States has a government-to-government relationship with them. So, when you get into sovereign immunity, which now is the next step, so you got the sovereign. So sovereignty is inherent right to self-governance. Sovereign immunity is a doctrine where the sovereign is immune from lawsuits.
Okay.
And this is the same for the United States or states. The United States actually has sovereign immunity from suits as well. So in order for a sovereign to be subject to a lawsuit, they have to consent to that lawsuit.
Okay.
So, and I like to just put this out here because it's not necessarily just a tribal thing. It's also even the United States. So maybe you've heard of the Tort Act.
Right.
So there's an act out there that specifically sets forth how an individual like you or I can sue the United States for torts, for negligence, for injury type things. And if that didn't exist, we wouldn't be able to do that.
And I imagine that same way with states as well.
Same way with states. They all have their own, and there's probably, I can't even think of off the top of my head, a situation where there isn't some type of law, like at a state level or even at the U.S. level, that would prohibit a certain type of suit. But, there are laws on the books that talk about how you can sue the government.
So it sounds like the sovereign has to tell you how they're willing to be sued, if at all. Is that correct?
That is correct.
Okay.
That is correct. And then it's the same with tribes.
So how do they do that? How do they indicate their willingness to be sued or at least entertain lawsuits?
Sure. So, what we're looking at is whether or not a tribe has waived that particular immunity.
Okay.
And, I think the thing that I want to drive home, and you'll hear me say many, many times, and that's that a tribe cannot be sued unless it has waived its sovereign immunity
Okay.
and it consents to a suit. So it's an absolute bar. It is an absolute defense. A great example, and let me just talk about this particular case. It's not an old case, but an older case from it's pre-2000. Very striking example of the nature of just how absolute this law is. There was a tribal entity related to the Kiowa tribe, the Kiowa Industrial Development Commission. They agreed to buy some stock, in exchange for a promissory note from the tribe. The note didn't talk about governing law, bore the sentence. I mean, this is like a really clear case, which just, is is interesting in and of itself. It's just so clear you wonder why the suit was even attempted in the first place. But it actually said on the note, nothing in this note subjects or limits the sovereign rights of the Kiowa tribe. So the tribe defaults on this note. I mean, there's no question that they gave the note.
Right.
Tribe defaulted, note holder tried to sue, and the case was dismissed. Just because there was no waiver of sovereign immunity, and that's it. They didn't have any judicial recourse on that note. None. Done. No. So, I mean, it really seems unfair, doesn't it?
But it's a complete bar. So.
But it's the law, right?
So
exactly.
If you don't know whether they're waiving immunity, it sounds like you better learn, so.
You better learn, exactly.
Right.
And that's why that's such an important concept. And sometimes I got to say, it's, we have our customers, we have us, you have these relationships with tribes, especially as owners, and, and they're great relationships, and, maybe you do business with them a lot, but I see contracts that specifically say nothing in here is waiving sovereign immunity. And I have to warn people and say, okay, I get it that we all get along right now. And that's wonderful. But we're not the people who are going to be fighting about this 6 years down the road when there's a problem and we can't resolve it outside of court. And no one is going to look at, court isn't going to look at that and say, well, I know it says that they're not waiving it, but, everybody was getting along. So
it's been a while.
You guys had this relationship. So, okay. No, I mean, it's very serious. If there is not a clear and unequivocal, and that's a word that's used in lawsuits, clear and unequivocal waiver, then there is no waiver.
And it sounds like that needs to be in writing or expressed in some way.
Yes.
To denote that.
Needs to be explicitly in writing. And there are even certain ways that it has to be done depending on the tribe and what their constitution says.
So that's interesting. So you're saying that each tribe may be unique in terms of its governance structure and constitution. So just because you've dealt with one tribe in the past doesn't mean that that's how it's going to work for another tribe. Is that correct?
That is exactly right. Each tribe, and I mentioned, one of the first things I do is go to a tribal website and look up, what is their constitution? What kind of ordinance do they have that relates to sovereign immunity? And it is a very broad variety of how those waivers can happen. Some may have a very simple ordinance that says, the business committee of the tribal council can waive immunity for contracts. It's like, okay, well, that's easy, Then you get other tribes that say any waiver of sovereign immunity, must be approved by a 2/3 vote of the entire tribe.
Wow.
Oh, wow.
Yeah. So then there would actually have to be a vote of the tribal membership, as if they were like voting on an elected office. It would be, a ballot initiative, if you will.
Right.
Yeah. So, and then everything in between. So it becomes really important to say, okay, just because even if there's a waiver in a contract, Mark, then you have to look at, did the business person, either the individual who signed it or the business tribal entity that is a party to that contract, did they have the authority to waive immunity? Because even if your contract says, well, okay, we're waiving immunity with respect to suit, relating to this contract, that's great. I mean, that's a perfect first step. But if you really want to be sure, which I think everyone should really want to be sure, you need to know whether or not that authority even existed in the first place.
So it sounds like not only do you need to assess the authority, but maybe you need to assess the scope of the waiver as well?
That is correct. That is absolutely correct, Mark. When we see a provision in a contract that waives sovereign immunity, they can be worded in many different ways, as any contract can. You may see something that says this is a waiver relating to claims by the contractor. And then that literally is all it is. Any claims that are brought by the contractor.
Right.
Period. Would a court agree that maybe the surety steps into the shoes of the contractor in case the surety, is in a position to bring a suit against the tribe? Maybe. There's no court case out there. And my motto is, if there's no appellate law on it, then I'm not going to rely on it, because you just don't know. And I mean, who wants to roll those dice and let a court decide something like that? I prefer seeing language that says, the waiver applies to any claims arising from the contract, period. That's nice. Right. or at least, claims arising from the contract by the contractor and or is surety also feels very good. So, some kind of language that is either broad enough or specific enough. I know that sounds counterintuitive, but one or the other to include the surety, is what I want to see, that we're not boxed out.
Well, it's kind of interesting. So now maybe you've looked up, you figured out there's authority, you understand the scope. Then where do you go? Do you need to know how that claim or dispute may be resolved? Do you get to go to federal court, or could there be required to go to a tribal court? How does that work?
That would be a whole other provision in the contract. Okay. So you have two pieces when you're looking at dispute resolution with a tribe. So as we just talked about, okay, is there a waiver of sovereign immunity somewhere in that contract? Has it been validly made by someone who has authority? Is it clear? Is it unequivocal? Does it apply to the contractor and the surety? Great. Then another provision is going to talk about what law is applying. Okay. It could say, everything's going to be tried in tribal court under tribal law. Sometimes that's okay. It depends on the tribe. If you have a tribe that has a very, well-developed body of law, some tribes, like the Navajo tribe has a very well-developed body of law that you can look it up. There's search engines that look at their law and their case law and how it's applied. Some tribes, when, as they're developing bodies of law, they will also rely on state law. For example, let's see, the Mohegan tribe in Connecticut is one of them, where their ordinances say, we have our own body of law, but if there's a specific area or a certain question of law that's not addressed by our laws, then we go by the laws of the state of Connecticut. Then there's ones that don't have a body of law and don't talk about whether or not the state is going to apply it. Then you're kind of flying blind a little bit. And so those are the tribes that, then I start to say to folks, we really need to negotiate that state law is going to apply. And we would like state courts. And maybe I should back up, because also two different things. What law is going to be applied is one thing. Right. And, the thing for me is, it's not always necessarily, are there specific laws that are more or less favorable on the books for the surety or the contractor? I mean, that's important. Don't get me wrong.
Right.
If there's something really bad, you kind of want to know that and try to not have that law apply. But really, it's how developed is it? How much are you able to look at the law and say, okay, I understand what this means. I can predict a little bit on where these type of cases will go, rather than, flying blind when it comes to how a court's going to decide
some level of certainty that you might be able to, yeah.
To the extent anything can be certain in the law, sure.
So, I mean, from your perspective, advising underwriters, how often are you able to negotiate those kinds of terms? For what law applies and where disputes will be heard. Is that something?
Yeah. Well, okay. Let's talk about where disputes can be heard, and that's just as another piece of it before I answer that question. Because the other piece of it, as you said, is where something is going to be heard, and if there's an indication that it's going to be tribal court, then you're looking at the court system and how that is set up.
Right.
The ideal for me, if I'm looking at how a tribal court is set up, is first in their constitution, and are things sufficiently divided, and kind of like the United States. Is the tribal council able to just summarily remove judges? That's a red flag. You want to have independent, you want to have appointed judges who then, have, there's processes to have them removed, which isn't just the tribal council can decide it, and then just, how it's set up. How many judges are there? Are the judges required to have law degrees? Some of them aren't, which, I mean, again, there are states that don't require law degrees either. But I mean, this is just all kind of all of the different factors coming together. Maybe they're not required to have law degrees, but, there's a ton of, there's 6 or 7 different judges, and they're, very independent in how they operate. Well, you take that all together. So that's what I mean when you look at the court system itself. And your question again was, God, you'd think it was Monday, but it's not.
Well, it sounds like there's a lot to know and a lot to research. And then once you do that, how often can you be successful in negotiating terms that you believe are fair?
Gosh, it really depends.
Okay.
It really depends. I have been involved in cases where we go back and say, we really need this to be state court instead of tribal court. And they come back and say, okay, that's fine. And you're like, great. I did my job for the day. Excellent. But then there are some other tribes that are just adamant. No way. It's going to be tribal law. It's going to be tribal court. And if you don't like it, we'll find somebody else.
Well, that was my question. Why would a tribe waive their sovereign immunity?
Sure. And I used to think that too. I'm like, well, gosh, forget it. Nobody can ever sue me. But, the reality is, the tribe wants to do business.
Right.
Whether that's being an owner, where, they want people to come and do business with them. They need contractors. They need vendors. And if they end up having just 1 or 2 people who are willing to do business with them because they're not waiving sovereign immunity, they're not going to have much competition. And all that's going to do is drive up the cost of any project that they want to do. When it comes to tribal entities that want to get bonds, well, that's an easy one. We're in a lot more, we're in a much better position then to just say, if you're not willing to waive sovereign immunity, then we're not going to give you bonds, period. And, I can't speak for all the sureties in the industry, but, I can say that, most of us certainly would not be willing to, issue bonds and enter into indemnity agreements without a waiver of sovereign immunity, because if you don't, your indemnity agreement doesn't mean anything.
So. Right.
How does tribal property play into this?
Tribal property is so fascinating. I mean, especially when there's an evaluation for underwriting, and I think this is maybe more important when you're looking at a tribe or tribal entity that's going to be a principal, and you're looking at an indemnity agreement, and of course, what kind of assets can be reached in case that, there is a need to enforce that indemnity agreement. But I mean, I guess you could also look at it from the perspective of there is some, boy, it's hard to even think of something that terrible in a dispute with an owner where, the assets of the owner outside of just, the cash that they have and whatever the building is where you're actually looking at their property. But, whenever you're looking at, an entity, like what kind of assets do they have? How are things going to be backed? And when you get into the property of a native tribe, ownership is just, it's complicated. I mean, first, just let me say, entire law school courses are taught on this topic. So for us to try to address it in a podcast is, barely going to scratch the surface here. So, I mean, let me just go back, give a little history lesson. Okay. On tribal property. So by 1887, most native tribes had been moved to reservations. And there was a General Allotment Act of 1887, which was passed by Congress. And many scholars and historians look at that and say that this act sought to eliminate the Indian reservations by dividing up all the communal property and allotting it to heads of households. And then the remainder of it was sold off to non-tribal members. So we're divvying up everything they own. Now it's not the tribe as an entity owning stuff. They wanted individual ownership, because when that happens, then people start to sell things off, and suddenly you don't have this centralized ownership of property. Once those individuals then owned the land, they were subject to local taxes. And many Indian owners were then unable to pay those taxes because it's a whole new concept for them. And then most of those owners who weren't able to pay taxes sold off the land to non-Indians. If you look at, and I found a map somewhere that kind of showed shaded portions of the Pine Ridge Reservation in South Dakota. And you can see where, there's a big block of land that is, tribal, the tribal reservation. Then kind of next to it, you see all these little pockets of where, land is still owned by the tribe. So there'd be like a little section of it, owned by the tribe. And then right next to it, one that isn't. And then the next one over is. So it's like this little checkerboard of ownership. And that, I think, is a very, clear picture of the outcome of this Allotment Act. It did exactly what I just talked about. So, continuing with our history lesson, by 1934, 2/3 of Indian land was converted to traditional individual ownership. And then at this time, the Indian Reorganization Act of 1934 and the Oklahoma Indian Welfare Act, and that was 1936, those were passed. This legislation slowed down the allotment, so that there was a change of tune in the government on how Indian land was going to be looked at. So, trying to slow down that allotment process, but what it didn't do was return to the tribes any of that land that was now individually owned. So, that's why we still have those maps that look like checkerboards. But the acts did allow the U.S. to purchase some of that land and return it to tribal status. So an effort was made to kind of undo some of the damage that was done. So I know there was a great exception to all of this, though, and that's the Osage Nation in Oklahoma. And back in 1870, they raised money by negotiating payment for land in Kansas that they owned. And then they turned around and purchased over 1.5 million acres of land in Oklahoma from the Cherokee. So they owned it outright because of the way that they did the purchase. So it's not federal trust land, and it doesn't have any of the restrictions on it. And we're going to get to federal trust in just a minute. But, they're a tribe that they really protected their land very, very well. So right now, today, there are a few ways that tribal land is owned. First, there's trust land. The federal government is the one who bought this. That's when they bought this back. They hold the legal title, and that's approximately 56 million acres of land.
Wow.
Yeah,
It's a lot. Yeah.
it's like about the size of Minnesota if you put it all together. But the beneficial interest for the land actually remains with the tribe or the individual Indian who depending on how that ownership went down. But it's protected from sale or default to non-Indians. So when you're underwriting and looking at assets, that's something else to take into consideration. If you're looking at property of the tribe, if it's trust land, then you can't reach it by execution anyway. So then there's restricted fee land, and that refers to land that the tribe or an individual Indian holds title, but there's legal restrictions against alienation, which means transferring ownership or rights, and it's also restricted from certain types of encumbrances. So again, might be difficult to reach if you have a judgment that you're trying to execute against the assets of that particular tribe. Then third, there's fee land. And when I say fee, I mean FEE. And legal term, don't worry about it. So that's land that can be purchased by tribes where they acquire legal title under certain statutory authorities. And any fee land that's owned by a tribe outside of the boundaries of a reservation isn't subject to legal restrictions against sale, encumbrance, unless there's like some sort of special circumstances, which again, won't get into right now. We only have, we don't have 3 days. Right. So, but the law in this area really isn't clear, though, on whether certain restrictions apply to fee land within the boundaries of the reservation. So there becomes a distinction. Is it on reservation or off reservation, even though it's owned by the tribe? So it's not easy. It's a little bit complicated. So when we're looking to underwrite a tribe, we're really looking at what kind of assets are there that are not necessarily land that we might be able to look to in the event that there's a judgment against the tribe and we're executing on it and trying to have that judgment fulfilled.
A different but maybe related question. So I know, like on any project, the contractors should do their due diligence about the financing for a project owner. I would imagine the same would hold true if you're doing a construction project on a reservation. What kind of process should the contractor go through to kind of at least understand the financing for the project?
Sure. It's not much different. Okay. Like you said at the beginning of your question, you're looking at the funding. Is there going to be adequate funding for this project? Where are the funds coming from? Is it fully funded already, or is it being funded by, the hope that there's going to be revenue from something in the future? Right. How certain are those funds? One of the things that becomes a little more important is where the funds are located. Okay. Are they, located in a bank or in, some kind of institution that's off reservation, or is it on reservation? And that becomes important if there is a judgment against the owner and you're trying to execute. When I say execute, I mean, I hope everyone knows what I'm talking about, and I apologize if I'm, I don't want to dumb this down for anyone, but, when I say the word execute, what I mean is if you have a judgment, then it needs to be fulfilled. If there's a refusal to fulfill it, then a marshal may, seize funds or seize property in order to satisfy the judgment. So that's what I mean. If your funds are being held on the reservation and you've gotten this judgment at a state court, and now you're trying to have a state marshal go execute on and seize those funds, good luck. That might be a little harder than going to Bank of America down the street. Right. So, again, an important consideration, where are those funds being held? I guess a little related to financing is, what kind of payment provisions are there in the contract? Is there a notice provision to stop work So, what is the stop work? If you stop being paid by the tribe, do you have to keep working? Do you have maybe 90 days notice before you can stop work? In that case, if, again, you get down to a point where maybe you're not as familiar with the tribe, maybe your waiver is not as strong as you might want. You've tried to negotiate, you're not getting much changes. An answer might be to consider an escrow account and an agreement with a bank outside of the reservation. And that might correspond to the number of months of peak billings and say, okay, we're going to put 3 months in an escrow account. So, if during this 90-day period where we've said, hey, we're not getting paid and we're going to stop work in 90 days, there is that 90 days to cover the work that you have to do when you're continuing. So there's another, that's just one of the other tools that you have to protect yourself if some of the other tools are not as advantageous as you might like them to be. And then, of course, the other question, what kind of retainage is there and where's that being held?
Yeah. Lots to know. Lots to think about.
To know.
I know it's such a broad topic that we're covering. I want to let everyone know if, this is a lot to take in just a short amount of time. But if you're interested, there is an article that was published in Surety Bond Quarterly that Michelle wrote with Brad Espinoza that talks about this more in depth. There's also a virtual seminar recording through NASBP that you can listen to that Michelle was also recorded for us. If you can get a lot more in-depth information on this, and I'm sure, Michelle, they can reach out to you if they want more information as well.
No, one of the things I say is, certainly, at a surety organization, if there's lawyers on staff, they're going to have some information on this. A contractor may want to reach out to their personal attorney, their individual attorney, to see, what they think about it and get their opinion. But, getting advice on this, it really is important because the details matter. This is not a place to just kind of cut corners and say, we all get along. It matters, every little detail.
And it sounds like that's the key takeaway when you're thinking about working with a tribe.
Yeah. Get it done up front, while everybody still likes each other.
Well, thanks so much for being on with us today, Michelle. It's been great having you on the podcast.
You've been listening to Let's Get Surety, brought to you by the National Association of Surety Bond Producers. For more information about the NASBP and its members, visit nasbp.org.
Before we go, we just want to say thank you again to Nationwide for their generous support of this episode of Let's Get Surety. For more information on Nationwide Surety Solutions, visit nationwide.com/surety.